We are.
All right, well, good afternoon, everyone. I'm Doug Kellner, co-chair, and calling the meeting to order. Introduce our commissioners. To my left is Peter Kaczynski and Greg Peterson, and to my right is Commissioner Andy Spano. First item on the agenda is to amend the minutes and executive minutes for October 23rd, 2017. So,
Are we doing them as a package?
do you want to do them as a package?
It doesn't matter.
All right,
But
and
I'll
then-
make a
and
motion
then
that
we-
we adopt them
All
for
right.
the October 23rd open meeting and the October 23rd executive meeting.
Second.
Those in favor say aye.
Aye.
All right, those minutes are approved. Then next are the minutes and executive minutes from December 15th, 2017.
I move that it be approved.
Second.
Those in favor say aye.
Aye.
All right, those minutes are approved. So then we'll move to the unit updates. We'll start with our co-executive directors, Robert Brehm and Todd Valentine.
Well, it's been a busy time since our last gathering, which was in December. The state staff, state board staff, and many individuals participated in the winter conference for the Election Commissioners Association. And we covered a number of topics that were related to the regulations that you see today, how to deal with the UO-CAVA classification of voters. Certainly cybersecurity was raised, as well as a number of other topics, and most importantly, answer commissioner questions. We did, Council's office completed the legislative packet, and Todd and I distributed that to the chamber and the senior leadership of the Senate and the Assembly, as well as all the members of the respective Senate and Assembly election committees. And it's also posted on our website for people to see the details. We have clearly started the election season with federal filings for United States Senator, and on Tuesday we'll begin the ballot access for designating petitions for federal office for the primary on June 26th. On the days. Tuesday, March 6th is our first day to start circulating petitions. Governor Cuomo on February 5th had called the special election in the 11 vacant Senate and Assembly seats. So the staff worked to get that information, certify a calendar, and distribute that information to all of the county boards of election that touch on any part of those 11 specials. 2 of those file here, the 102nd Assembly District and the 107th. So tomorrow is our deadline as a staff to certify the candidates in the special. There are no prima facie issues that we're giving you today with regard to those ballot access, because we didn't have any problems with those ballot access. We have one general objection, and today's the deadline to receive a specification of objections, so there's a slight chance if we receive something that there'll be a need to call a meeting with regard to any determination that might come out of that. So we'll just need some flexibility from the commissioners. It's not very likely, but if, at least we're letting you know it may happen. We'd have to schedule something if it comes to be. Certainly a lot of the other work that's on here, we've all been involved with. Todd and Tom went to the NASED conference, and they could give you a better first-hand account of the work at the federal level to mostly it's been focusing on cybersecurity. We have the budget. As you know, we submitted a full ask in the budget for approximately $15 million in additional funds. Some of that was for personnel. A lot of it was for contractual services. The budget, as proposed in the 30-day amendments, provides an appropriate, a information in the budget with regard to a $5,000 amount of contractual money for cybersecurity.
5 million.
5 million, sorry.
We'll just say 5,000.
Sorry. So from our understanding is that it's confirmed it's a dry appropriation right now, so hopefully as they talk during the budget, that will be real money in there by the time the final budget is adopted. It's subject to a plan that the staff have been working on developing. So we will, certainly depending on what the final budget looks like, keep an eye on those items. Yes.
When you say it's a dry appropriation, what do you mean by that term?
Well, it's a spot to put money in, but there's no money in there right now. So, so we'll see if it's subject to where the money will come from, that if they like our plan, they'll move the money there. That's still unknown. Where is the money? Or will there be money in there before the budget's finally adopted? I don't know that part, but all I know is right now it's a spot to put money.
So we can't spend any of it.
I guess you can't spend what you don't have.
So we as you know, we've talked about the budget. We certainly have need at the staff level. I think Todd puts the description pretty easy. It's kind of like when you get on the airplane and they tell you to put the oxygen mask on you first before you try to help anybody else in the plane. So we have to make sure that the statewide voter registration list and the statewide system is protected before we can really worry about the counties connecting to it. Because that's our vulnerability that we have to protect, and then we have to work with the counties in order to help them. So our focus has been on all of the items that we identified so far that cost more than $5 million, is to try and prioritize the items that we can accomplish right away, that are higher priority that need to be done, and try and focus on how much of that can we get done in the next fiscal year within the proposed amount of money.
Well, we're also trying to leverage any free services that are available from the Federal Department of Homeland Security that has available for risk assessments, as well as to help counties go through what they call tabletop exercises, which is basically a drill on what would you do if this happened, how would you respond to that. And we're planning a series of 6 across the state is what they would support. So, basically do it regionally wide and work from there with what we got, so.
And one of the key items, there are many items that the Federal Department of Homeland Security will help states with. One of them is to do the risk assessment, so we're applying through Bill Cross to the federal government to have them do our risk assessment for the state board to come in as a free service. They also will do that work for county boards of elections, so it'll help us to adhere and then try and encourage those counties that need that free assistance to also apply for it. At the federal level, Department of Homeland Security has placed this work as a priority. There is a bit of a waiting list, so we're trying to get that information to apply, to be on the list, and then to adjust if necessary. The NICE voter upgrade of the entire computer system has been happening over the last couple of weekends, and we have a March deadline of target, as I understand. So it would really help to have that done before somebody comes in and does a risk assessment.
It's March, Bob.
Well, I know that, and he's confirmed that it's March 2018 for me, so I keep working that.
Okay. I just wanted to remind her, it is March.
So we have a lot of people working on it, and so far he hasn't told us that there's a problem. But it's significant to get that work done, and it really will help us to upgrade and to deal with some outdated software. So we're waiting for that to before the federal government comes in. So certainly we will experience, I don't know if we're the guinea pigs, but we'll at least experience their interaction with the Department of Homeland Security to do our risk assessment. And hopefully that'll be a good service for free for the counties. And depending on what happens with the budget and whether or not there's real money or not in that pot, we would then have to focus on as many free services as possible or low-cost services, anyway, because we've identified about 14 million and we have 5 million.
So you're anticipating 6 regional meetings with Homeland Security and our counties? Is that what you're, and when are those going to happen?
We're working now to set up the first one, so if all goes well, we anticipate a first one to be towards the end of March and finish them by mid to end of May, knowing we have that Easter Passover period to work around.
Did we ever have a follow-up on the recommendation I made at the convention, remember, about the security designation on each county?
That is, we've been looking at, it's part of our security designation already for voting machines. We're looking at that for security in general as to what a regulation might be that we adopt that put a requirement on every county. And that's one of the items that's in there. In the draft, we met with, it was a conference call, but with the head of the state tax department. They had recently adopted regulations with regard to cybersecurity. So we had a conversation with them as to a number of items, adopted that. And that's one of the items that's in there.
I'm talking about? When we were at the convention, this whole area of cybersecurity came up. And I said, wherever we've had, in the past, we've, records management, we've got a records management office. You have the, any kind of FOIL request, you got a FOIL request office and so on. It doesn't involve a lot more work. It's just someone who's focused on this. It's not a new job. Because each of the counties is different. The small ones, big ones, etc. Some of them have problems with their IT department. Some of them, so if they had a series of questions, 4 or 5 questions that they answered and reported to it, they just made checks on an annual basis and whatever else you could think of, and reported to us things like a commissioner dealing with an IT director in a small county may be a problem. But if we knew there was a problem, we could deal with it somehow from here, which would be a little better, and we could get more done. But we would keep up on at least the problems that are going on. That's
Good.
That's all it was.
Yeah.
So we had started to look at the draft of the reg, and
Modified for us.
depending on what
Yeah, and
other
I
services.
talked to both sides of the aisle when I was there. I mean,
Right.
everyone was okay with it,
Well, makes sense.
So the concept is in there. We're just trying to figure out what are the duties and training to go around on it. So we certainly have been looking at that as part of what we're proposing and trying to train around. And we've had a pretty good luck reaching out to county IT departments and county boards. We've had, since your last meeting, we've had 2 alerts that we have passed on to the counties that came from either the state troopers or the federal Homeland Security contacts. There have been a few other, I wouldn't call them alerts, but just helpful suggestions or current trends in the industry. Some of that has been coming from MSISAC and others. When we receive them, we review them in-house, and certainly with IT, and we've been basically sharing those helpful hints with a little instruction to the counties. And when we send them to the counties, we've been sending them to the contacts. We have both the county IT department and the county Board of Elections, knowing that in many of the counties it's a joint effort to protect the election infrastructure at the local level. So it's been very active in both our traditional bread and butter kind of getting on the ballot issues as well as the cybersecurity issues.
So is the idea here to bring Homeland Security in to assess the risk level that our counties have in the state to a potential cyber attack? Is that the idea of these meetings around the state with Homeland Security?
Well, no, those series of meetings they're tabletop exercises, and they're designed to have counties go through how would they respond in the event of an incident occurring and what is their readiness for that. So it's a learning exercise on that. The risk assessment is analyzing your system as it sits today, and what known vulnerabilities do you have that you should fix that you haven't. And I'll give you an example of a risk assessment. One is on if you have passwords to your system, because we're doing this ourselves because we identified as a vulnerability, where you have people that had left and you don't clean up old passwords, or you don't have a consistent password process to change them on a periodic basis. That's a known vulnerability because somebody gets the password or leaves, they can, and if they have, and what access does each password have? So if they don't need administrative rights, you just don't give them to everybody. You should only go to the certain users. So that's one of the risks they look at, and how you.
So is that kind of assessment being done?
Well, we're going to do that. We've done an initial review of that. That's part of what we did as a survey last summer to get some initial information from the counties on that, and that did alert us to the problem. We do need to do a more detailed level, but that's where Homeland Security is a little short on resources because there's like 9,000 election jurisdictions and they don't quite have that many people. They are ramping up. They can do it at a state level, but that was part of what our spending program was, to do an assessment of the counties.
So is that part of the $5 million that would be appropriated? Is that would give us the resources to do that sort of risk assessment at the local level?
But part of ours is, from our perspective, eventually the county will have to learn to do this as an ongoing requirement, and perhaps in our regulation to require a periodic risk assessment of the county. But our hope was, with the money, was to have helped them to bring them up to a plateau, a requirement level of, let's do a risk assessment, figure out where the holes are, and then try to mitigate as many of those holes as are the higher priority right away as part of the budget, as part of the
I guess I'm just
spending
concerned if this $5 million doesn't get appropriated, let's say, and it remains in its current condition, that we won't have the resources to do those kinds of what I would consider to be necessary assessments and potential fixes to our election system in the state to protect us from this.
Yes, I can't argue that.
I'm sure I'm not, I guess I'm preaching to the choir here,
Yes,
but I
we
think,
all agree with that.
but I think we need to make sure that we, pursue this as much as we can.
Well, when the budget first came out and there was money there, we raised that in a monthly call with the county commissioners, that there's money in the budget, that we're working to come up with a plan, and that it wasn't as much money as we asked for, but at least if it's a continuing appropriation, it's not a one-time and over, because certainly cybersecurity isn't a once and done kind of thing. It's a going forward kind of requirement. So we weren't quite sure what help we would be able to give the county, but we said that at least our plan is to include them in that help. On Friday's call with the county commissioners, after we learned it's a dry appropriation, we at least alerted them that they should, that it's a dry appropriation. It will depend on the final budget, and whoever they told at the local level that there was certain money, they should tell them that they should make phone calls that it's less certain, and that we will do the best we can, depending on what the final budget looks like.
I understand. I just think we should, make sure that those across the street who are doing the budget are aware. And I mean, I know we didn't even get what we asked for. I know this $5 million was short of what we asked for, but now to have it we may not even get that, that's a concern. I think we were somewhat satisfied that, you know, the 5 million would get us to a stage where we felt comfortable that we could provide the services that are needed, but if we're not getting any money at all, that's a whole different ballgame, and I think raises a whole other set of concerns. I just want to make sure that we're transmitting that to the people who are putting the budget together, that, you know, this is, hopefully would be a priority.
I think we all agree
I think
on
we
that.
have, and I know we have at both the Senate Assembly and the Chamber. We've had a number of phone calls since we learned on Thursday that it was a dry appropriation with many people in all of those.
I don't know
arenas.
that there's a whole lot more than we can do. I mean, we've told the decision makers, I think we've fully briefed the decision makers on these issues.
And we've urged the counties to also
Good.
let their local elected official know how important this is to them.
Okay.
All right, anything else?
No.
So we'll turn to our Council and Compliance Unit, Brian Quayle and Kim Galvin.
Thank you, Commissioner. I'd like to start off by just giving a little bit of an overview on some of our cases. The LLC case is in the appellate division. The arguments have occurred, and we're awaiting a decision in that particular case. The Eason case, which is pertains to the accessibility of the State Board's website to persons with visual disabilities, is proceeding. We're in an expert discovery round 2 stage right now, and there's a trial that is, if it isn't settled, scheduled for the end of May. In the Merced case, which deals with the process of independent nominating who's capable of being a witness requirements. That case, motions for summary judgment have been made by both the plaintiff and us, and is in the near final briefing stages, so that decision is moving forward. In the Merrill versus Sliwa case, which had gone up to the appellate division relating to the Reform Party organization and the validity of their rules, the appeal in that case was dismissed on technical grounds, and a new notice of appeal has been filed, and a motion has been made in that case for a preference, and so that's back on the docket. In the Common Cause case, related to ballot, NVRA compliance with respect to inactive voters on the part of the board has made a motion to dismiss and requested oral argument, and that's the last docket entry as of January 12th. In the Parrish v. Kaczynski case, which relates to village petitioning witness statements and who's capable of being a witness on those petitions, we had stipulated to a judgment and order in that case, and the plaintiffs had made a fee application. The magistrate judge has recommended a fee application amount, and that is awaiting certification by the judge. We have one ballot access case, I think, in the 37th Senate District related to the Independence Party Certificate of Authorization, which is returnable on March 6th. I think that's our current case posture.
Quite a lot of litigation.
Always a lot going on, So it's nice to just give a little thumbnail of that.
And compliance?
Yes.
Where do we stand in our statistics?
Right. In compliance, couple statistics. We have, as of March 1, 2,531 failures to file for the January periodic. The total number of reports reviewed by the compliance unit stands at around 92,000. of which around just shy of 80,000 of those reviews have been completed. And the ratio of compliant to deficient to training, I won't run through the exact numbers, but it is running pretty much steadily as it has. We have received one request to make an assignment under 6218 to a hearing officer since the beginning of the year, and a hearing officer has been assigned. It's my understanding that the report has not been, we have not received notification from the Chief Enforcement Counsel that the report has been served, so we don't have that in the file yet. We have two HAVA administrative complaint procedures complaints that have been commenced since the beginning of the year that are both moving through the process. And let's see, in other areas, we had a meeting in January with the Department of Justice to answer their questions related to list maintenance procedures under the NVRA. So at some length, we reviewed those procedures with them. It was a listening session. We also discussed with them an issue related to the DMV and in particular the possibility of amending the DMV address change form so that that form would be able to stand as a voter registration form, so it would accomplish not having a two-step process when a voter moves across county lines. Under state law, as the commissioners know, if a change of address is received via the DMV process, but not the whole form, and the voter has moved within the county can simply change and update the address. The DOJ, in their interpretation of federal law, believes that it's important that that address transfer can occur across county lines, and to accord, or I should say, to sync the federal law with state law requirements. There was a discussion about making changes to the form to allow both statutes to be satisfied. Let's see. I'd like to. It's an opinion that Mr. Cartagena worked on Bitcoin that was shared between both sides of the council's office. I just wanted to touch on this. It's kind of a unique situation, and the course that I would like to recommend is a little bit different. And Mr. Cartagena certainly can provide a summary of the opinion, but obviously with cryptocurrencies coming into the forefront lately, the question has sort of arisen is how are those treated by political committees if they receive contributions of Bitcoin, and are they analogized to cash because of the certain attributes that they have, or are they analogized to, say, securities or something like that? I think everyone agrees Mr. Cartagena drafted a very thorough and cogent opinion, but it is an area where there is a lot of evolving thinking on this subject. I know the legislature is also thinking about it, and our thought was that we should share the opinion and see what, for example, the appropriate bar association committees or other regulatory entities that are looking at this issue might have to say about it, because it is such a new and emerging thing. That would, and I think, because of that, we wanted to sort of ask the commissioners what the thinking would be on that kind of a procedure.
Well, it's an interesting topic, I agree, and I did see your draft. I thought you did a good job. Has the FEC weighed in on this?
They have. They've concluded back in 2014 that they considered crypto or Bitcoin, because that's what I think the opinion was limited to, as an in-kind contribution. However,
and that creates a problem under our statute if we follow that model.
The IRS did the same thing.
The IRS considered it the same way the FEC did.
Right. Now, I will note that even though it's an in-kind contribution under the FEC's opinion, there's still a $100 limitation because the questioner limited it to $100. The question was, can we accept $100 worth of Bitcoin? And the 6 commissioners do have a diverging view after that. 3 commissioners said the $100 limitation was essential to their opinion that Bitcoin be accepted as an in-kind contribution, while 3 other commissioners are more of the opinion that there is no $100 limitation in regards to accepting Bitcoin as a contribution.
So the suggestion, Commissioner, is that we circulate the draft to the election law committees of the bar associations and the good government groups and solicit comments.
You say the legislature's working on something as well?
Well, there's no bill, and it
But I mean,
seems
as,
to me
as
that
a general issue, though,
Well,
maybe not in the elections arena.
I
but-
think they are holding hearings on it, and I think the Department of Financial Services is still working through some of the regulations that they have on it. So things are, as they said, and as Nick's opinion pointed out, that it is a very evolving issue. And we have talked at length about the various, different ways that this could be treated. And I think, personally, I think it would be a good idea to solicit some external opinions on this as well.
Yeah, I mean, I'm fine with that. I'm just trying to understand the direction we're going. Are we going on our own here, or are we going to wait for the legislature or the, some other governmental agency?
Well, I think our situation is unique with regard to whether or not it can constitute a campaign contribution. So in that variation of it, I think that we would have to figure our own way out. But certainly looking at the various ways that these other entities have treated it and how they treat it, and there's issues of anonymity, there's issues of the various fluctuation in pricing, there's a variety of things that have to be considered, in my opinion, before we can come to a final consensus.
Yeah, I mean, from what little I know, it doesn't seem to have a fixed cost attached to it. It does seem to fluctuate.
But it's similar to a stock.
So, I mean, I can see where that's an issue of trying to value it as to what the
and
value
I
is.
think that if you handle it as solely an in-kind contribution, that you could actually open up a loophole where people would use it to avoid full disclosure.
There's also the issue of if you treat it as a currency similar to cash, then there's a built-in prohibition under the law about cash contributions in the aggregate over $100. So there's a kind of a built-in protection there. So really, is it a currency and you're going to treat it as cash because of the anonymity issues, or you're going to treat it as an in-kind contribution as a good, or in this case, a stock or some kind of instrument like that? So it raises, there's all kinds of permutations that come out of it, and it's developing.
And I think ideally, we should make a recommendation to the legislature, because even if we adopt the opinion, it's only an opinion, and without legislation, whether it'll be binding is another issue. But we're not there yet.
Yeah.
So I think raising these questions and asking for comments from interested groups would be productive.
Yeah, and certainly it isn't limited to Bitcoin at this particular time, because there's various emerging cryptocurrencies, 7, 8, or whatever that is referenced in the memo, and there's more developing. So I think the question arose originally through the compliance unit, is my understanding, of someone called up and asked a question, and, so therein lies the discussion, and there's been quite a lot of discussion. So I think any input we could get would be helpful.
So do we have a consensus that the council should circulate?
Sure.
Absolutely.
something? Okay. All right, is there anything else? Well, I guess I had one comment that you said there was 2,531 non-filers for January, and is that just the January periodic, or that's the cumulative non-filer list?
That is just the January periodic.
So that's a record, isn't it? I mean, that's the most non-filers historically ever, I think. And is that a factor of the fact that there's no, or virtually no enforcement anymore?
I think, Commissioner, that's about consistent with what the non-filers are.
2,500?
It's about a consistent number, and it's generally 75% of those are local C-filers, and 25% are the state filers.
The number for January, the January periodic in 2017 was 2,105. Your statement that it is a record. The report that I have in front of me only shows the last since 2016, so I only have 3 years. But it is the biggest number in 3 years, I believe.
Yeah.
Do we see much difference between January and July as far as numbers go?
It is, by way of reference, in January 2017, the initial number was 2,105. The July number was 1,879. So it, relatively similar, within a few hundred.
So we're talking about each year 5,000. I don't know.
Well,
Files aren't
often it's the
made.
same committee.
Yeah,
No,
it's
but I
the
mean,
same
but
committees.
individual,
You
no,
can't-
I'm not talking
Yeah.
committees, I'm talking individual filings are not made, give or take.
Yes.
But those committees have been, a significant number of those committees haven't been filing for several years.
That could be, I'm not saying any different, but it's a large number.
And those committees, if you look at the numbers, have significant numbers of judgments against them. So I'm not sure that there are.
But not in the last couple of years, is that fair to say?
That's true, absolutely
Those
true.
are judgments that predate you.
Yes, but they're not committees that, those committees that were not filing continue not to file. The fact that they got judgments before didn't, in my estimation, cause them to file because they were sued and got judgments.
Do we have any,
I
do
would
we
like
have
to-
any evidence of that?
I do want to weigh in. 'Cause I mean, certainly, we've had a discussion here before about how perfect the list is, and I've conceded that, there obviously is, there are some issues with committees that perhaps, we should find a better way to get them off the list. But there's some really solid evidence that the process that the board previously followed, so I will refer to 2014 as an example, that the process itself, which we are not presently following, resulted in that. So by way of example, I just gave you the numbers for 2018, but in 2014, at the point of the 5-day letter, there were 2,400 letters that went out. Ultimately, at the time of the order to show cause, there were 559 committees to add to the order to show cause, and then there were 409 judgments that.
I'm sorry, Brian,
that
can you go
came
back
about.
over that again for me? I'm missing a little bit here. So you're saying that, what are we talking about, January of 14?
2014.
Okay,
So,
so how many didn't file in January of 14?
2,400 and.
Okay, so
That-
then you have the 5-day, that's pre-5-day letter?
Correct.
That
Okay.
is the number at the 5-day. That's when
Okay,
they
so
got
now the 5-day
letter.
letter is sent out at what point, like 2 weeks out?
I don't know Bill. When
It's usually it was like a month, right? 3
Yeah,
weeks or a
more
month
like a
that would
month.
go out.
Okay, a month, let's say a month.
No,
So
no.
after a month or,
It's typically within 10 days of the date the filing was due.
10 days, okay, so within
That's
10
why we
days
call
you
it a
send out a
5-day letter.
5-day
No,
letter
wow.
which says
There's no question.
you have not filed, you must now file within 5 days, right? That's
Yes.
what we call the 5-day letter.
Yes.
Okay, so that letter goes out to those 2,400 filers, and what happened?
Then what ended up happening is between then and I don't have a date, but whenever the prior enforcement unit brought the order to show cause in Albany County Supreme Court to compel, to seek a fine for the non-filing, the order to show cause number of committees that was listed in the order to show cause was 559.
So of those 2,400, we're now down to 559.
Yes.
Is that correct? So almost 2,000 of those filings came in? Is that what I'm to
Well, the
assume?
compliance staff has argued repeatedly that the 5-day letter was the most effective tool to bring those non-filers into compliance. They have repeatedly urged
Well, coupling with the fact that
the enforcement was coming.
that once we filed in order to show cause, they had to pay something.
Correct.
Well, then actually, yes, and then between the filing of the order to show cause and the court actually signing it, so that in other words, the board discontinued against committees that came into compliance after the order to show cause but before judgment. I shouldn't, not signing the order to show cause, the judgment pursuant to the order to show cause. The ultimate number of judgments that was received was 409.
Okay, so another 100 came in.
So 1,600 about the 2,100. There was no judgment here.
Bill was here during that time. Is there anything missing in that?
No, that's about the par for the course. Now, I will say, I think that a lot of committees just relied on the fact that if the filing was due, they would get the 5-day letter and treat it as a notice, like, oh, I better get it in or else. And certainly, I think it had a prophylactic impact on that. But that's certainly not the case anymore.
So with that in front of us now, Reese, so how do you,
Because
do you
not
still
all of
believe
them-
there's no evidence that an effort by this agency to pursue these people is ineffective?
Well, I don't agree with the numbers that, the cold numbers that are presented are accurate in terms of how many committees filed and how many of those committees that got letters were sued. That in the subsequent July filings, the numbers, again, who didn't file, didn't go up. And then the January periodic, again, didn't go up. So I don't have the numbers in front of me, but I don't believe that those stark numbers reflect the accuracy of how the autopilot litigation was effective in getting people to file. Because if that were accurate, then committees wouldn't have 24 or 10 or 5 or 3 judgments. It just wouldn't happen. And over again.
So you're talking about the effectiveness of actually commencing a lawsuit against a committee and actually getting a judgment against them, and whether that act is sufficient and is productive in getting people to file. But what about the 5-day letter issue? What about the evidence here that they're showing, it seems, that the mere sending of a 5-day letter to 2,000 committees is productive and does result in a large number of coming into compliance?
I think that it didn't bring people into compliance. I think what happened is that people called, got to pay $100 or whatever dollars, and then they went on their merry. Okay.
Yeah,
I understand what the numbers are that they're saying. I don't think that that's what actually happened.
So now, in our current state of affairs, when we have 2,400 not file in January of 16, what happens? Where are those now? Have any of those come in? Is there any indication of how many of those have now complied? Is there any way to compare?
The numbers go down statistically every few weeks because people file late generally. So you'll see the numbers go down.
Do they go down at the same rate they went down when the 5-day letter was being sent?
I think that they probably don't go down as much, no.
So you would agree the 5-day letter was productive?
I think that the
getting people to
5-day
come
letter
to compliance?
probably had some effect, yes.
If I could just
but you're no longer sending the 5-day letter, is that correct?
Correct.
So
Because
if you agree that it's productive, Reese, so why don't you send the 5-day letter?
Because the list upon which it's based, in my opinion, is still not accurate.
But even if it's not, what's the harm in sending the 5-day letter?
Because the people who get the letter are generally not responsible for filing. The list at this point is just, Kim, you can shake your head.
Those are treasurers you're sending it out to, I
Yeah.
assume, right?
Well, if I can just clarify, there's the distinction between filers, first and foremost. Firstly, the 5-day letter, which is a notice that you haven't filed, it's not just a letter. It also had the threat of the or else. We sent that out as required by statute, certified mail, and also by first-class mail because we wanted to give extra notice. With candidate committees, there was a marked distinction because the statute under the Carmel Call Law required that in addition to sending out that notice to the treasurer, if it was an authorized candidate committee, we had to send it to the candidate also. So it's not only the fact that there was a letter that was sent out by first-class mail as a bonus, if you will, because we wanted to get more compliance, but it also went to the candidates. But it was also the threat, which then was ultimately carried through of the lawsuit. Now, I will certainly agree with the Enforcement Council that there are a number of recalcitrants, recidivists that carry forward each year, especially as it relates to periodics. However, what you then met, and I will also add just by way of factor, is that Julys are typically a little smaller than January's because of the election cycle. Typically in January, you're coming out of an election cycle, and if people haven't yet terminated, et cetera, with their post-general report, they have an obligation to file in January, and then people will typically terminate. And then when you get to July, you're ramping up to the next election cycle, particularly for local filers. And so now it's really after July that people might start to form their committees. So July is historically going to be smaller than January. But it ultimately comes down to the number of recalcitrants, which I might also add is typically your PACs. What you're missing is that in each election cycle, when committees register, whether they're state filers in the even years or in the odd years more local filers, it's those brand new filers who file and register, who then get on the list, who would be more apt to then be responsive to it. They're not the recidivists who just don't care, and they can have judgments pile up on them ad nauseum, but it's the annual ebb and flow of new filers that letter and process would have the effect of getting people into compliance. There's no question about it. And so to send even a postcard that we send now, whoop-de-doo. I mean, a postcard just says, hey, and it's just a notice to say there's a filing due, and if you have to file, that'd be nice, you should do that. But that's not the same as getting a certified letter in the mail. It also goes to the candidates that says if you don't file, this is what's going to happen. You get sued and the judgment will be entered, et cetera, et cetera. That's a whole different process.
Okay.
Commissioner, could I ask
Well-
a question?
Go ahead.
Well, John, just a minute ago you said you don't believe our numbers. Have you done
I'm
your
not,
own
you know
analysis?
what, I've done several analysis and I don't.
Can we see your analysis?
No, you cannot, and I don't answer questions from Mr. Conklin. Thank you.
Well, as you know, Risa, this has been a source of frustration.
Absolutely.
I think for the 4 commissioners, I think I can speak on all of our behalves in this area. I frankly don't find your answers very satisfactory. I think you've conceded that based on Brian's numbers, there is some usefulness to this 5-day letter and this process that the board had used for all those many years trying to get people into compliance. Why you don't adopt that is beyond me.
I will adopt
useful,
a process when I know that a list that I'm using is a valid list. And I've said that over and over, and we do this over and over again, and perhaps when the new system comes into existence, I can rely on a list that will justify me sending out a letter that threatens litigation. And until I have that, I will not use that list.
Commissioner, I can just add one cogent point, though. The list isn't reliable. The judgments aren't reliable, but yet when a case is brought to a hearing officer, it's cited directly in the memorandum to the hearing officer, the litany of judgments that are held against them. So if you're bringing a procedure to seek potential penalties against a filer on judgments that you say you can't rely on, why do they then form the basis of a proceeding brought in through the administrative process?
Fair enough. Brian, do you have something else?
I do, and I don't desire to bring the commissioners through territory that you've gone many times before and to trod over these fundamental disagreements. But one of the things that I said at the outset, and I would like to underscore, is that the process itself previously helped to clean the list. And it's important to remember that every treasurer who files a piece of paper with us is saying, I am the treasurer of this committee, I am the fiduciary, and I am responsible to do the things that the law requires me to do. And that piece of paper is filed with us, and they're told when they become a treasurer that until they do the things that they're supposed to do under the law to relieve themselves of that obligation, they're continuing to keep doing it. The idea that the people who are on the list are not actually responsible for the filing, I think is hard to understand. They signed up for that. There's no doubt that because of the passage of time, because of fact circumstances, or people have gone beyond, or things of that nature, that as a practical matter, obtaining compliance from them is not possible. All kinds of things like that. But the reality is that on the core point of, is the list accurate with respect to committees, as a list of people who said, I am the treasurer and I'm obligated to do this, it is. It is.
And I just have to say that, I just have to,
How much does it cost to send this?
You mean the 5-day letter?
You got a 5-day letter, right?
I don't know. Do you have any idea what the budget was for the 5-day letter?
That's like 2,000 people. What does it cost?
First class.
The certified, those go certified
Mail and
mail.
certified mail, so first
And you're
class
sending to
is
the treasurer and the
50 some odd
candidate.
cents.
I don't know. Thousands of dollars, I'm sure, but I don't know.
Yeah, it would be thousands of dollars, because the first class mail is about 50 cents right now. And then the certified's, I don't even know what that they're charging for it now, but
10 grand?
Less than
I don't think it was that much.
not that
I don't
much,
think it was that much.
but it would
I
be,
gave
it
the
would,
number on purpose.
it would be a
Yeah.
couple $1,000s, you know, plus you have to have envelopes and paper and all that stuff. It's not just postage.
How much, how would we spend 10 grand to find out if this argument can be settled?
Just to do.
I
to
think
do
that,
a
I think
mailing?
that we could send a letter that says, we have sent this to the enforcement council, and should you not respond, she has these options, and go through all those options that we talked about before, and see what happens. We're not doing anything that law doesn't allow us to do.
I guess we could. I don't know if we could or couldn't. I guess what I'm trying to understand, though, is why our enforcement council?
I know.
But what I'm trying to understand is, I listened to this argument, I don't say much on this argument, I listen, because it's being articulated very well by the rest of the commissioners. But we're never gonna solve it unless we do something. I mean, one person says one thing, the other person says another thing. Let's see what happens.
You know something, I agree. There really is no, that's an excellent suggestion that we necessarily, as a board, do what we did before, get the letter out, and frankly, we could show Risa, look what happened. On the one hand. On the other hand, Risa, this is not an adversarial situation. What is being said here, basically, put all the criticism and everything else out of your head for a second, what it's basically saying is, there was something that worked. And frankly, I don't see, sitting here trying to weigh both sides, I don't see why you just don't do it. It's not a big deal. No egg on anybody's face. Do it and let's see what happens. It's not a problem. Shouldn't be a problem. And then, by the way, if it doesn't work, you can come back here. See this? I did this, you guys. You were all wrong. Frankly, I think you'll wind up seeing that it was probably effective. It's another tool that you'd have. So I don't see why you have an objection to it. And by the way, and if it gets sent to somebody who it shouldn't be sent to, the guy goes, "Hey, what'd you send this to me for?" Oops, sorry.
I get those
boom.
phone calls a lot,
Fine.
Commissioner.
We've had them in the past too.
Well,
So
I
you-
understand
then
that,
you yank
but
them
I
out and
don't.
that's it.
See, the problem is I don't threaten litigation in those situations. I just don't. It's not the way I do business.
Well, it's not a bad tool.
It is a bad tool.
It isn't, because you're saying,
It
if
is.
you have done this, you will bear the consequence. There's nothing wrong with that. If you steal a pen from this table, you will bear that consequence. It's the same thing. Fine, I didn't steal a pen, so I got nothing to worry about.
Oh.
So I fail to see the logic of your position.
Yeah.
Anyway, all right.
Well, I know we've been over this, but
But maybe we should do what Commissioner Spano has suggested, do it ourselves, and let's see what happens. Got nothing to lose. We're certainly not making any headway this way.
Just the amount of money.
Yeah, what, a couple $1,000, that's it.
Well, I
Take
think
it out of that spurious account that he's got over there with nothing in it.
Anyway.
Whatever's left.
All right, so I think we should move to election operations, Tom Connolly and Brendan Lavillo.
Thank you, Commissioner. Just to kind of recount a couple things that have already been mentioned, obviously we've been receiving a number of filings for the upcoming elections. We did receive 7 certificates of nomination for the 102nd AD and 7 for the 107th. We also received 1 independent nominating petition for the 102nd. We did receive 4 certificates of nomination to date for the federal primary in June. We did receive also all related and necessary authorizations and acceptances. We did receive, and there's on the agenda later on, some filings for governor, which on the prima facie review were deemed invalid, so we'll have those for you later on. As such, we've been finalizing the certification for the April 24th special election, which is to go out not later than tomorrow. We'll be finalizing the statewide kind of certification of offices to be filled next week. On the voting machine front, we have started the certification procedure for the Dominion ICE machine, which is the Image Cast Evolution, the ballot marking device modification. That's including meetings with NYSTEC, who we work with internally, to discuss the approach towards the testing procedures. Meetings with Dominion regarding some of the issues that we've encountered already with the equipment as far as just part of the testing, and also the creation of test cases for going forth the certification testing. We also received an assessment from SLI, one of our independent testing labs, about an engineering change order for Dominion. Their central count system uses an all-in-one computer. The one that was being used is no longer being sold, so they were replacing it with a newer model from Dell of the all-in-one computer, and the SLI assessment was that was de minimis. A lot of things on the cybersecurity front obviously was mentioned. We've been working with other units about developing the tabletop exercises with DHS. I did want to address one thing that Commissioner Kaczynski had asked before about whether or not the counties would be able to avail themselves of some of those services. The tabletop exercise itself is usually around a 2-hour event. We kind of liken it to a play where you kind of can see people in different roles that would be familiar, and you present them with a realistic but still hypothetical scenario, and you kind of explain what would you do in that. So it's a good learning experience. Bill Cross and I had gone down to New York City to watch a tabletop exercise that was conducted by the FBI, which had nothing to do with elections, but I think we both saw the utility of conducting such exercises. In fact, there were people from the New York City board who were also at that tabletop exercise. We've been working with DHS on phone calls to try to develop who should be involved in the planning process and what kind of scenarios should play out. As part of the idea for conducting those tabletop exercises across the state, we're looking to probably do a 3 to 4 hour total event. So if 2 hours of that event is really the exercise, we want to leave time for discussion, questions, but also the possibility, because there will be DHS staff on hand, for them to kind of go through some of their various offerings that they could then offer directly to either the county IT people who will be there or the county boards of elections who will be there. Anywhere from vulnerability assessments to kind of more in-depth surveys. There are also a number of self-assessment tools which DHS provides, which could also be provided to the counties. I know that Bill may mention it later on, NYSBOE, which is the state organization of IT directors, is having a conference in July. May. And they had actually asked if we would be interested in presenting, so I think that we'll probably take up that offer, just to kind of help create those kind of bridges, because we realize that on the county board end, that their relationships with their county IT can sometimes be very varied as far as the closeness of that relationship. I've been working with IT to also engage DHS about some services that we will be taking on. They have 2 of them in particular. One is the RVA, or the Risk and Vulnerability Analysis, and the other one is the Cyber Infrastructure Survey, which is a little bit more in-depth. We've been in contact with DHS. We are in the process of completing that paperwork so we can at least get in the queue. As we've heard from a number of different people, we are being moved, by we I mean the elections sector, to the top of the list, but obviously there are a lot of people in the country who want to avail themselves of the services, so that queue is still kind of building, so sometimes it's a matter of a couple months wait. Later this month, I'll be attending also with PIO, the Belfer Center, which is out of Harvard University. They had developed some cybersecurity playbooks for both campaigns and local election officials. They are conducting a 2-day conference on the 27th and 28th of March, which is kind of like a train the trainer for tabletop exercises. Part of our goal internally was to try to conduct our first tabletop exercise towards the end of March. use that and the lessons learned from that experience, also the lessons that we learned from the Belfer Center experience, and then work with DHS to kind of tweak things as necessary for the remaining 5 exercises. As far as conferences go, as was mentioned before, I did attend the NASET conference down in DC with Todd. In addition to that conference, there were also meetings with the Government Coordinating Council of the elections infrastructure sector. With DHS, I was also able to attend a meeting about securing voter registration databases with the Center for Election Innovation and Research. And also, there was a public meeting of ERIC, the Electronic Registration and Information Center, that I attended. I also, the Center for Internet Security, which is based over in East Greenbush and is the parent, organization of the MSISAC, which is the Multi-State Information Sharing and Analysis Center, which gets talked about a lot with regard to cybersecurity. It was designated while we were in DC by the Government Coordinating Council as to be the elections infrastructure ISAC. So basically, they're the ones who are going to be collecting a lot of the intelligence information and trying to distill it down in a meaningful way for both election officials, but also IT officials that work with those elections officials. So I'd worked with CIS, the overarching organization, on the development of a handbook for elections infrastructure security, which was rolled out while I was down in DC. I took part in that with a couple of other state officials over the past 2 months. That has been received very well. I like the approach because it breaks up into a couple of different parts. It focuses on the cybersecurity of election infrastructure, but one of the parts really kind of speaks in a very non-technical way to some of the more policy people, or the general county board commissioners. But then there's also a list of 88 different controls that, with a lot more specific information with regard to IT, that county IT staff can implement. We also had obviously was mentioned, the winter conference. We participated in a couple different presentations. Brendan and I also participated here with the new commissioner workshop. Then staff also attended the Dominion and ES&S user group meetings. Following up on accessibility and usability, we are continuing our conversation with the Center for Civic Design, which the State Board has worked with in the past with regard to both usability and accessibility. We're going to be working with them on ballot design, but also form design. They do produce a set of 11 field guides that talk about how to kind of improve accessibility and usability. I did discuss that at the conference with the county commissioners, but I also was able to get a set of those guides for each county board, so we sent those out to each county board so they would have that set of field guides. And we're going to be working going forward with both Dan Chisnell and Whitney Quesenberry from the Center for Civic Design on a number of different fronts. We were working with IT as part of the Eason case to remediate some of the content that's on the website for accessibility purposes, and also to make some changes to some of the interactive systems to try to make them more accessible. We've also done so with some of the documents, for example, the filings that have been received for both the April 24th special and also the federal primary. We've been posting the reports that we've always posted on the website, but we've also been posting optimized reports for screen readers. As part of the certification that we've been preparing for the special, I've been doing that or remade that in a way that it is accessible from the get-go. And so the idea is that if we can kind of distribute things one way that covers both bases, that's a lot easier than having 2 versions, one separate. So we're going to continue working on that. I had scheduled some basic accessibility training that covered 24 different staff members here. That was very well received. It kind of was covered for 4 hours, just 2 half-day sessions. Some basic accessibility principles. I am scheduling another half-day session for anyone who was not able to make that, and then 3 more half-day sessions of more advanced topics for people in Word, Excel, and Adobe Acrobat, so that we can better understand how to make our content accessible going forward. On a miscellaneous front, we participated in conversations with DOJ. I had a conversation with them yesterday. I believe the 2 co-chairs received an email from the DOJ with regard to our UACAVA, or our military and overseas voter population. Obviously, we're going into a federal year, so they are very keen to make sure that we're all set to comply with the federal law. I did have a conversation with them yesterday. We did run through the various election dates, what we've done so far and what we plan to do as far as educating the county boards as to the deadlines and making sure that they themselves comply with that, and any kind of changes on the legislative front. I did discuss with them the regulations that were on the agenda today for the special federal voters. To that point, we've also been finalizing some of the guidance for county boards on how to treat these special federal voters as described in the new regulations, how they would go about it in their own local systems, how those local systems, the local voter registration systems, should be matching up with the state NICE voter system, so we can make sure that's a smooth transition. We have been participating in demos of the new CAPA system for candidate management with IT. We've been finalizing the annual statistical survey that we've been collecting from the counties in addition to receiving their annual reports. And we had sent out contract extensions for the shoebox funds, which the counties use. We have to renew that every year, and we've been getting those signed documents back. Although one thing I do want to jump back, obviously we were working with council on some of the comments we received with regard to the audit regs, and we've been working on finalizing the procedures for the audit tool. One of the commenters, Dr. Mark Lindemann from Columbia University, we had reached out to Brendan. Brendan spoke with him this morning. We are going to try to meet with him. I know there's a lot of interest on some of the commenters' ends with regard to risk limiting audits, which have been discussed briefly here at some of the board meetings. So we're going to be probably trying to set up a meeting with him just to kind of hear him out and learn a little bit more about the whole process. Besides that, do you have anything? No, I'm good. I'm all set.
No, I don't think we need to take up any more time.
Tom, can I ask a question?
Sure.
Any Pepsi, that was a lot of information.
Only one coffee.
By the way, I want to just tell you that was.
Only a little about election ops, though.
Well, I guess maybe that's true. You said you had a conversation with DOJ yesterday about our implementation of the overseas voter. What was their reaction? Do they feel our deadlines are compliant? Are they concerned in any way about what we're doing or what our timeframes are under state law to comply with the act?
No, I think they're fairly comfortable as they've worked with me over the past, since I've been actually at the board, and they do know that.
It used to be us, but now it's just
They're fair. I do let Kim and Brian know when they call, but they're fairly okay with me just talking with them. You know, they realize that I'm going to usually hound the counties as we get closer and closer to make sure that we stay compliant. And we've been doing a good job at that for the past few years.
So you're saying it's more about people actually following the law than it is about the law itself?
Right. No, they didn't really have any issues with our law because they understood that we have obviously the different deadlines under state law for state and local offices versus the federal law.
And to his point, we used to be a very bad state in compliance.
You mean we weren't adhering to state law, we weren't getting ballots out? Or federal law, I mean. Or state law. Don't we have state law on this now?
But then since Tom has took over the reporting and the follow-up with the counties, it has gotten remarkably better.
Good.
And I think we're in the good state category now.
Okay. It is. So DOJ just does these periodic updates with every state? This is not
was a
just
form letter
indicate
that
there's
you
a
got.
problem?
Right. This is more of a run-up.
Because we'd gotten that letter, and I just didn't know. Was that something?
It was a form letter that went to all the states.
Right. In the past, they would have not necessarily sent it to you. They probably would have just sent it to Kim and Brian and myself. They did explain to me, he actually called, DOJ called me before they sent the email letting me know that this was just part of their new procedure that they were going to be sending it out to kind of like the heads of each state.
Okay.
This is what they kind of do at the beginning of every federal year, just to make sure that every state is poised to like make sure that they comply with the federal law. Okay. So.
Can you tell us about voter registration compliance issues on the county level? I know that there's been a lot of discussion in New York City about New York City implementing list maintenance procedures following the entry of the consent order. And can you just tell us what's going on in terms of state monitoring?
It might be easier for perhaps at this
Thank
level
you.
than perhaps
Go ahead,
ops. Since the Brooklyn situation, we, the state board, had put in place.
That's 2 years ago.
April of 2016. A weekly syncing of the two databases, the city and the state board, in addition to what else is happening, and staff looks at the numbers to make sure that there aren't any anomalies that are identified. Recently, the staff had identified a change in the number, and they alerted us. Shakeman, as the staff member, sent out an email generally to us at the staff level that they had identified a change in the numbers. The identification happened a week after a conference call that the senior team of people, includes John and Todd and I and a few others, IT department, as to some of the changes we were making to the list maintenance information we were going to share with the counties, based on conversations to provide better information to the counties to take act, or at least to review as potential matches. So we weren't sure, when we saw the numbers, were they that quick to some of those changes we had just given them or not? But I had a call into Director Ryan anyway on something else, and I said, we just got this note from our own staff that noticed this, and he had indicated to me that he had covered the details in the week before a public meeting at the city board as to what they had did. He did assure us that it did not include the more recent list maintenance things that we gave him because it was too new. It was some of the older things. And basically, there was litigation that came after the Brooklyn situation, and they pretty much had a freeze on what they were doing with some of the dupe maintenance, felons, deaths, until that litigation was settled to make sure that they were following the proper procedures. But since it had been settled, they had then implemented some of the things that had been deferred. So it included people where the information that was provided by the state as to potential duplicates where people had registered outside of New York City had been reviewed. It also dealt with pending felons, pending deaths. Another category that they had in during the period of time that they looked at was they might have treated someone as a duplicate in their system, but it also identified as a death or a felon, and they had inadvertently not made the connection to both parts of their file, so it didn't completely capture those, but they had known about them during the review and the discussion.
So the state board is reviewing this, and we're on top.
So we had one, we identified the issue immediately, and we had made the call. I did share the information generally that this is what he had, and the report identified it. So I don't think it is a critical issue, other than they were doing the appropriate stuff that they had agreed to do in the consent decree, was to have a meaningful list maintenance where there will be people removed from the list because that's what appropriate activity. And in some instances, they're inactive with a confirmation notice and waiting to federal general elections if they don't respond to then be removed from the list. And in other instances where death, some of the other situations would allow them to be canceled sooner. But he had assured us of that, and I did get a chance, or at least Cheryl did. It is covered in the minutes that they have posted online with some of the statistical information. There will be others that people will notify if I can, since if people are interested. During the conversation with the city and other boards of election, we had modified the information that we share in the area of felons, deaths, and potential duplicates. And we had a small example. Middle initial was a mandatory match field. So if Robert Brem was in the county record of the old county, but Robert A. Brem was the county record of the new county, that would not match because we had a mandatory middle initial field. So we have now removed it as a mandatory match. If one says Robert, Q. Brem, and one says Robert A. Brem, it won't match still. But if it's in one and not in the other, it's a potential match that will go to the county as at least something they need to look at. That identified a large number of people that were potential new records that we had not shared with counties before. With regard to deaths, we made the decision to go backwards in time to a period, and I believe it was 2007, but I'd have to check for sure.
That's the beginning of
But
that.
that's when we began Nice Voter. So we gave some historic information because we felt comfortable that going backwards would be okay in the area of deaths, because it's not like you re-registered somewhere else after dying. In the area of felons, and moves, we did not go retroactive, we just implemented that going forward, so we would provide new information to people. Because a potential felon dupe, if it was old, could have completed their maximum sentence and re-registered. And if we provided that retroactive look for that data, they might have made inappropriate decisions. So we just informed, we did a call with New York City separately because they have a larger percentage of the list to make sure that they understood what we were proposing. It was conversations we had had with New York City all along. And then after we had the conversation with New York City, it probably was like a Tuesday, Wednesday, we had the monthly call with all the counties on that following Thursday and shared the same information with all the county boards, sent out an email reminder, and then we started to implement on a going forward basis those changes. So people will see in the area of deaths another a group of them probably in the April 1 enrollment numbers, because New York City really was trying to look at the window of when could they do certain things this year with a special election, with a federal primary looming, with a September primary, and they had encouraged us to get them the death information early because the window was like now to actually have the staff review it and perhaps be able to take a better look back, since it was a large file. So we will see more number changes on April 1, we anticipate.
And Bob, we had also done the name changes?
The DMV mismatch. The third part of it is the DMV, what I call the DMV mismatch, which is if the first three letters of the first name match, the date of birth, the DMV number all match, but the last name doesn't match, you may have a potential match because it may be someone who's changed their last name, most likely a female, but not always, or you may have a data entry problem. So the record needs to be looked at and assessed if there's a misspelling, if the DMV number has a bad number in it, and those things can be corrected. So that was another set of potential duplicates for the counties to receive in the NICE voter system, in addition to what Bob said, the deceased and the felon.
And am I correct that the lawsuit that was challenging the Nassau County list maintenance procedures was dismissed? And that's resolved?
I confess, I do not know the answer to that, Commissioner.
All right. And then somebody mentioned an issue with Westchester, and is that now resolved?
We had looked at Westchester. It had, when they were doing the November enrollment report, we had noticed a change in Westchester, similar to the Brooklyn situation. Reached out to Westchester, and they had it was close to the window, so they had restored those individuals, made sure their names appeared in the poll book. I think it was a question of timing. Could they make them inactive just prior to printing the poll books, or did they have to wait until after the election? But we had noticed when they did the November numbers that Westchester was off slightly. And when we called down there, they had put them back so that they didn't have a problem on election day. It would have been appropriate to make them inactive after, but not that close to the election. So we do look at them, and Shake does a great job for us in the IT department to try and alert us, and the alert goes to many of us.
All right, great. And I want to thank you because you included the usability issues in the report, so I don't have to ask questions about that. I can see that you're working on that, and that's good. The last item I had for operations was to ask about the close contest in Clinton County, and if you could review that situation and write a very short report for the commissioners on what happened, because I understand that there were, again, issues and anomaly in the canvass process, but I'm not, from reading the appellate division decision, I can't tell whether the hand count that actually occurred changed the outcome, or whether the hand count was generated because the clear ballot process simply alerted the canvassers that there was an issue that needed to be reviewed. but I would appreciate learning the details of it, so that we can continue to make the record of where we have identified places where the machine count has not been accurate.
Sure thing.
Great. All right. Anything else for operations? All right, then we go to public information, John Conklin and Cheryl Kauser.
Thanks, Commissioner. Well, public information has been busy since December. Lots of calls about the January periodic campaign finance filings, the April 24th special elections for the 11 vacancies in the state legislature, the cybersecurity issues that are in the paper now, it seems almost every day. In addition, we, like everybody else, attended the winter conference for the Election Commissioners Association, and members of the unit made some presentations for that. As Brian mentioned, I think previously, there was a new law passed last year requiring us to publish campaign websites for state offices. The statute was effective December 1st, and the board was given 6 months to draft regulations. We have regulations in the packet today to be approved. That's a consensus draft that different parts of the agency have worked on. Ordinarily, it would not have come into play until the petitions that were filed in July, because that would be the state offices for the fall. But with the special elections April 1st, it is effective now. So that's why we're going to do it as an emergency regulation. In addition, the unit participated in the monthly ECA calls in December, January, and February. We continue to be part of all the meetings about cybersecurity reviews and assessment. We processed 70 foils in December, 115 foils in January, and 104 in February. We were continuing to participate in the calls on the implementation of the Executive Order 169. We participated in preparing materials for some of the lawsuits that Brian and Tom mentioned. We were part of the meeting with DOJ to discuss the monitoring of NVRA Section 8. We have sent out an email asking the agency units to prepare their portion of the 2017 annual report, and please get those back to the PIO by March 15th. There has been a discussion about the agency taking on the winter conference as its own annual conference. So Cheryl and I have been attending various hotels that would fit our needs in the area. We're not sure if that's actually going to happen. There was some debate about whether that would happen, so it's a little bit on hold, but we have visited a number of sites, and we're prepared to move ahead if that's what ends up being the decision between the ECA and the agency. We received our delivery of voter registration forms this week. We have approximately 500,000 on hand here at the board, both English and Spanish, and we had another group of approximately 300,000 that was delivered out to the counties, both English and Spanish as well. We assisted in the cyber security tabletop plannings that Tom mentioned, and we'll be part of those as those move forward. And Bob mentioned the changes to the matching procedures in NYSBOE. That was going to be part of my report as well, so that's been covered already. So in terms of the website, for the April 24th special elections, we posted nominations, the governor's proclamation, and the political calendar for those elections. We posted filing nominations for the U.S. Senate. The webcast and the transcript for the December 15th meeting has been posted. The 2018 legislative package has been posted. The campaign finance filing calendar for 2018 has been posted. And the campaign finance compliance webinar has been posted as well. Lastly, the unit, since the last board meeting, has visited Dutchess, Rockland, Putnam, Warren, Rensselaer, Saratoga, and Monroe counties for nice voter reviews. So anything you have to add, Cheryl?
I just wanted to raise that the legislature passed the bill that would move the September primary from September 11th
to the 13th, and it was sent to the governor on February 20th, and the governor has till March 3rd to sign it.
And we sent a letter of support for signing that bill.
On the website, where is the URL going to appear?
We'll put up a special page, certainly for this election, the April 24th election, and then it'll be a list of the offices,
Is
the
it a hot
candidates.
button?
It will be. Yeah, it will be. Yeah.
Is there any thought of reconfiguring the page at some point?
Well, I think for the fall election, when we have the full slate of the whole legislature and all the statewide offices, I think that is what we will probably do. We haven't completed all those internal discussions yet, but I think that is what we will do.
And just,
Is there any search capability on that page? Or is there any thought of putting on? I put my address in, I get my candidates.
We have a search feature already to determine who your elected officials are. It's in a different spot. I don't think we've raised the idea of marrying the two. It's not a bad idea. We can certainly explore that.
I think the more and more we can marry that kind of information, the better it is for the voter. It gives them, brings it right there, simply. I know it's not easy.
Good idea.
And one of the things I may mention, I know Bill will probably cover it in IT. Obviously, we've talked about it at a number of different meetings with regard to the redesign of CAPAS and FIDUS. Part of CAPAS for the candidate petition process has been trying to figure out how to better get candidate information from county boards, because obviously we have the information for people who file here, but we may not know all the information that's filed at the county board. So if we can get that information to our new system, then that's certainly a way that we can then provide that back out to an end user. And like John was saying, we do have an elected officials lookup now where you can type in your address and it'll tell you what districts you're in and who your current representatives are and show you a map of the district. That certainly could be repurposed for also then showing you who's on the
All
ballot.
the candidates that you would vote for at
Correct.
that address. So I think
Well-
that, how about pictures?
Pictures of the candidates?
Yeah.
Well, we don't have a means to provide that yet.
No, I'm talking about that. I understand. I'm not just, because I think that if you get this in a comprehensive format that has a lot of information like that, it would behoove the state to put out advertisements during campaigns to go directly there, not even just steer people to it. Because if the two candidates put up their own websites, when someone says something, they can go to the other website and look at what the other one said about what this one said. And they don't have to depend on all this rigmarole we're talking about in the newspapers, television, etc. They can look at it more quietly. They can make up their own decisions and so on. I'm talking long term, down the line.
Do you think it'll solve our cybersecurity problem of fake news? Because
We can have, you know-
then we might have some money to do this.
A whole new target for hackers.
We'll add that, we'll add that to our
We have to do
plan.
it, and we have some capability to do it. We ought to do it, or at least try to do it.
Well, this is a brand new road for us to put that kind of material on our website for purposes of any kind of campaign. And I think we can explore what you're talking about. We have to be extremely careful because balance is one of the most important issues when you're doing that. If one campaign, for whatever reason, doesn't provide you with information and the other one does, and even though you put a small disclaimer there, it still puts us in the middle of a situation where we're showing information for one campaign but not the other. And whether it's our fault or not, some of that blame will be directed at us.
That's politics.
Okay.
But, just the fact that someone doesn't do it is a statement. That's all I'm saying. I mean, if you have no money, you have a website. I mean, people know to do that when they run for office.
They certainly do.
Great. Anything else? Then we'll turn to information technology. William Cross.
Good afternoon, Commissioners. I'll start with projects. CAPAS FIDUS. We remain on track for the current development schedule, which I've sent it here previously. That hasn't changed. We are on track still. We continue to have resource issues, however, as I've mentioned in the past. We're fully staffed in terms of contract-based help, but we're continuing to work to fill 2 permanent programmer positions that are vacant, and in addition, a networking position. Continues to be a challenge filling at the civil service level, but we're trudging through it. In terms of funding, I reported last meeting that we were requesting the balance of capital funds from the Office of IT Services to fund the project. I'm happy to report that those funds have been transferred to BOE, particularly to pay the contract-based help we currently have. It was mentioned, I think, by Tom. We're based on previous data collection and the county working group meeting we held in September. We prepared an updated survey for the counties to give us feedback on the type and format of information that they currently manage, and so we can incorporate it into our system and possibly make it as well, publish as well. We've received responses from all but 2 counties. We appreciate it's valuable feedback we can use in development of the new system. In other development, we like I said, it continues on track with EFS use cases, political calendar. We're starting ballot access functionality and continuing with data conversion. We're also implementing, per the new legislation, the capture and publication of the candidate campaign websites, both as a means to capture into the current legacy system, and then we've built it into the requirements for the new system as well. For Nice Voter, as Bob indicated, we are in March. We are in the final stretch of updating our infrastructure. All the new equipment, all the new software, everything's installed. We're currently going through the process of migrating legacy systems over to that new environment. We've had activity every day, every weekend, pretty much. We are shooting to have it complete in March. Things are going well. We've taken some hits with staff time, but we're pretty close. So, as Bob knocked, I will do also. For Move, the process is also continuing development for the in-house Move application to replace the outsourced application, and that's progressing. And I think I mentioned last meeting also the state Office of IT Services is requiring that we again move our data center to a new location. We've obviously resisted because we're right in the middle of redoing our entire infrastructure, and we need to work around specific calendars, particularly the special election coming up. Nevertheless, we are working with them to and their related vendors to plan the relocation. It is inevitable. We've yet to set a particular date for it. Cybersecurity, the benefit of going towards the end of this is I think most of everything I have on my sheet has already been reported. But I'll reiterate, as part of the new fiscal year budget, we sent some of the pretty comprehensive list of security initiatives to improve both the state and county BOE systems. Based on the proposed budget, we've worked further to prioritize these initiatives, but there's a serious concern about the reality of the funding. While we fully intend to take full advantage of free and low-cost services, such as those from DHS that we've mentioned, there's serious ongoing threats to election systems that we can only be mitigated by an investment in proper protections and technology. So there is a concern there. Nevertheless, we maintain a plan going forward of what can be done short-term and long-term, and try to do the best we can with it. Again, there's been a few mentions of the tabletop exercises. We're working with the group internally to craft those for DHS. And also mentioned is we've begun the process to engage DHS to perform a full risk assessment for our own systems here. Very much as a confirmation of the new build that we're putting up in Nice Voter For the website, as expected, the website traffic has pretty much returned to normal levels following the general election. So stats for December, January, February are on average about 200,000 views per month for our main site and about 50,000 for voter lookup. That's all I have.
Anything else? Great, thank you. So we now go to enforcement. Risa Sugarman.
Good afternoon, Commissioners. First, I'd like to say Happy Purim. I brought my grogger, if anybody would like to use it. I did participate with ITU and my staff on Capus Vitus. We had a meeting with the staff. They asked us to present. We discussed the issues for enforcement and how we would interact with the new system. The meeting, I thought, was very successful. We had a lot of questions. They had a lot of questions for us. So we're in the. I think we're finished with the memo that we're presenting for them in terms of the new system, and I'm just about ready to send it to them. And that's that I have. If you have any questions for me.
Anything?
Thank you.
All right, we'll go to old business. The first item is vote for final adoption of the new regulation, Part 6219, on special federal voters. Is there a motion to approve it? Do you want to have any discussion?
Second motion.
No.
All right, those in favor say aye.
Aye.
All right, the regulation is approved. The next is the opinion of the board on expenditures to 500 or more persons. Is there a motion to approve that?
I'll move that.
I'll second.
All right, is there any discussion? All right, those in favor say aye.
Aye.
Approved. All right, then,
I have one more item, if I could.
Certainly.
One more item under old business I'd like to bring up. At the last board meeting, we had a discussion about releasing information that occurred in an executive session in October. At this meeting, we did adopt minutes from that meeting, which I know at last meeting we did not adopt, so we were discussing releasing the transcript of the meeting. And I know there was some uncomfortableness with that, and we ultimately haven't done it. But we did adopt minutes today from that executive session. I would like to reiterate my call that we release those minutes. I think that what occurred in the context of that meeting, in the discussion and decision component of a subpoena that was issued, would be important for the public to know. I think that the discussion was educational. I think the decision is also very important, that the people out there who are engaged in any activity related to office holders or campaigns know what the decision was and what the discussion was. So I would like to reiterate my call that we disclose or we release those minutes from that meeting as an educational tool for the public at large to understand the direction this board is taking in the context of that particular item.
I could be heard on that, Commissioners.
Sure.
And what, just by way of just a quick little bit of background, at the last meeting, the commissioners asked Kim and I to look at the documents related to the October executive session and to come up with some proposal as to what would be appropriate for release. And of course, you rightly note that at that time the minutes did not exist, so I've not done that specific review for the minutes. It was based on the transcript at that time and on the enforcement documents. Kim Galvin prepared a proposed redaction. I reviewed her yeoman effort in that regard, and my conclusion was that even redacted, that it was possible to identify exactly what was involved. in that particular matter, and that the nature of the matter being such that there could be additional rounds of information sought, and the fact certainly that the board does have the authority to release these documents, but nonetheless, it was my view to recommend that in as much as it's an open investigation still, and there is at least hypothetical or theoretical harm if the nature of the particular investigation were to become known, to suggest that at this time the board not release anything. And then, in having read the transcript, not of that meeting, but of the December 15th meeting, it became very clear that the commissioner's objective was an educational one. And you reiterated it again today, Commissioner. The objective is to have the regulated community understand certain important issues about an area of the law where there is a disagreement as between the commissioners, and the desire that the regulated community understand what the nature of that disagreement is. So what I suggested is we could consider doing an opinion to the extent that we agree, but it could also underscore areas where there remains fundamental disagreement, or do something we haven't really done before, but given the importance that the commissioners have placed on this particular topic, we could do a policy paper that would essentially potentially articulate both views and then articulate what the differences are. And it is my opinion that such a policy document could even indicate in the abstract, for example, that it appears that the Chief Enforcement Counsel leans more toward this one versus that one, which could have the ability, I think, in a very expository manner that is well considered, to actually provide more insight to the regulated community as opposed to less. So that would be my recommendation, and I'll pass it to Kim for her thoughts.
I don't really have any thoughts on what Brian just said, other than the transcript was clear. You told us to exchange drafts. There was a comment made that there were words also in there that should be removed. Mr. Quayle made that comment. Commissioner Kellner said no, just the identities. I did so. I was fully expecting a return draft to come back after my initial redaction attempt, which I didn't receive. Brian had all along told me that there was issues surrounding the release and the knowing of who the complainant was. I reiterated all four commissioners' assent in the transcript that if you could redact the identity, that they all agreed in the transcript to seemingly release it at that point. But I took him at his word. We had a lot of discussions, and then ultimately the decision somewhere was made that this would be the conversation instead of a motion to approve something that we had agreed on. So
I do not fully agree with that characterization. I have a different take on it. But I think in going back to the penultimate statement during the actual discussion that the commissioners had in December, it was clear that we were directed to look at the documents and to come up with some proposal as to what would be appropriate for release. That's a direct quote. Ultimately, I was not able to conclude that anything was. Ms. Galvin, in good faith, concluded that something was. And in part, my recommendation in this regard is based on the fact that I was able to take a phrase that was in Ms. Galvin's draft and Google it and immediately identify at least the parties that were involved in this particular issue. And that in reading the redacted draft, and as it might need to be further redacted, by the time it would be completely redacted, it would be nearly completely useless in terms of an educational tool. So thus the differences in our, I think, principled disagreement about what should happen.
Okay, well, fair enough. I'd like to just have a discussion amongst the commissioners then, I think, if the staff can agree. I do think this is an important issue, as you know. I brought this up at the last meeting. I'm going to bring it up here again today because I think the nature of what was done in that October meeting is much broader than the specific instance that was before us. I will grant you there were facts specific to that particular discussion because we were looking at a specific item. But I think that the discussion itself and the conclusion has much broader implications, and I think would be very educational and useful for anybody out there practicing in this area to understand what we concluded.
So what do you think of writing up a policy statement?
I don't think that accomplishes it. I think the minutes go much further towards just identifying the issue and making it very clear what the discussion was and what we were doing. You know, a policy discussion, I'm not sure where that gets us beyond what the minutes would do, I think, in a much better way, because you could see right there what people said and what their thought patterns are and what their conclusions were in this context. You know, a position paper, to me, I'm not sure what that does. I'm not even sure what form that would take. We clearly have a disagreement at the commissioner level on this particular issue, but I think it's a fundamental issue. I think it goes to a very fundamental issue as it relates to enforcement of the election law in this state.
You're talking only about the October meeting?
At this point, I am. I'm talking about the October 23rd meeting, yes.
Do we each get one to?
If you want to bring one up, Commissioner, I'd be happy to entertain it. If you have some meeting.
No, but I mean, that's what it boils down to.
No, it doesn't. No, I don't agree with that. I think if you identify a discussion in an executive session that you feel is of that nature and you want to bring it to the commissioners for release, I'm open. I'm willing to discuss it.
Suppose it's 2-2 and it doesn't go out.
Then it doesn't go out. I get that. And I mean, we're having the same discussion here. I'm just prompting it because I thought this one, and we did agree in March of last year to have a policy where if we felt there was that type of discussion in an executive session, that would be something to release to the public.
I agree.
I think this fits within that policy that we adopted back in March. I mean, I will say to you, this was the first one I identified, but I'm not going to say I'm closed-minded that there might be others. I'm willing to entertain them. I'm just bringing this one to the table.
Conceptually, I'm with you, okay?
Okay.
But he's my attorney.
Okay.
And I got to practice. If I hire a guy or if I get an attorney, I got to listen to him.
Okay.
And I've mulled over what he said, I mulled over what you said, and I can't go along with it right now.
Okay. Well, I mean, I can't make you do what you don't want to do, but I'm just bringing it because I think it's important.
I just don't want people to get the impression.
And I thought there was some agreement or certainly understanding at that December meeting that we all agreed it was important enough for release. It was just how are we going to do it? But now we're at a point where we're releasing nothing.
You heard the analysis.
I did hear it.
Okay.
I did hear it. Doesn't mean I agree with it. I just heard it.
Yeah, okay.
The fact that I hear something does not mean I agree with it,
No, I
Commissioner.
know.
Let me just say that.
Well,
But I have
And this
a
would fit
different
into that
relationship.
category, I might add. I don't agree with that at all.
It happens in court, too, things like
It does. It does. I'm used to it, no question. Happens all the time.
Look, we're at a very delicate balance here. When you go into executive session, it's obviously executive session because there are certain discussions that will be had, and I think everybody in that executive session should be have the freedom to speak their minds. Otherwise, we limit what the usefulness of an executive session is. That being said, they'll say something and you don't necessarily want it broadcast in public when you're discussing a hot button item, shall we say. However, the other part of it is that we set down in that session a different channel, a different direction, which frankly people out there should be very interested in because they can guide themselves accordingly, those who have to report, et cetera. I certainly agree with Commissioner Kozinski on this, that, yes, at certain points we should release it.
But wouldn't it be better to write it up as an
no.
opinion or a policy statement so that?
Except that within the context of what we discuss, sometimes that sheds a little bit of a different light on it. Again, as I said, we're in a very delicate balance here to try to maintain privacy on the one hand and yet full disclosure on the other hand. And certainly by releasing something, let's say a synopsis or a direction which Brian was leaning toward, is appropriate. There's also another possibility here too, because apparently we don't want to do this because there's still certain things that could be brought to light somewhere down the line, in which case, fine. You want to put it off, but there should somewhere come a point where we say, it's all done, it's over with, let's release it.
Well, when Risa makes her referral.
Well, just in fairness too, I'm sorry.
The investigation is still ongoing, right? And they have not fully complied with the subpoena yet?
the ad itself comes up.
Pardon?
I said, just in fairness, if you do the Google search, as Brian indicated, not only does the target come up, the fact that the target made the complaint and the actual thing that was in question all appear in newspaper articles in the past 4 months. So it's
Right.
not a big secret.
Right. Which sort of cycles back to my point, is that we shouldn't do any of this stuff in executive session, and that everything should be public.
The thing that I would note on that is the difference is not just the subject matter, but the awareness of people that certain things are occurring with respect to that subject matter is different. It's not
Right,
just
I agree.
identifying what it is, but it then telegraphs to certain individuals with respect to something that something is happening. And if you're at all concerned about spoliation of evidence, particularly in the kind of case where it's a peel the onion kind of case, then there should not be a disclosure
Where
until
it
it's
is
concluded.
that type of case, I do agree with you. However, in
think
this
it
case, the
is that
person
case.
admitted they made the complaint, they talk about the ongoing State Board of Elections
I
investigation.
think too much has already been said.
I agree. Thank you, Brian.
Well,
Thank you, Brian.
I tend to agree that a lot of this, most of this, all of this is out in the public in some way already. And, you know, the idea that there's some big secret here and some big confidentiality that we're protecting, I think is just misplaced. I think that it's out there. But more importantly, in my view, is that this is a much larger issue than this one instance. Because if this is a decision we made in this one instance, and it can easily, I believe, be extrapolated to any number of other instances of similar nature, it's not fair that the public is not aware that that's the direction we're
But
going.
then I think we should write it up as an opinion or a policy paper without putting our thumb on the scale on this particular investigation.
Well, I don't think we're putting our thumb on any scale. I think we can do it in a way that doesn't compromise the investigation, but accomplishes the bigger goal of getting the information out there so people are aware of what they can and cannot do in the context of these types of activities. I think right now we're not being fair to
And
the
how
public.
is an opinion not address that?
Well, it delays it. I don't know how we're going to craft an opinion on this. Obviously, we don't agree on it, first of all. Secondly, we've already got minutes that articulate, I think, pretty well what the discussion was and what the decision was. I don't know why we need another document to do the same thing. I think it's very clear right there. I think this follows our policy that we adopted in March, which was we would release minutes when they, I thought, met this standard of a policy decision made in the context of an executive session. I think it meets all those criteria. I think we have the perfect instrument to do this with, and to not do it and then push it off onto some other avenue, it just doesn't make any sense to me. I know, Commissioner, that you're in favor of transparency. I think this is a perfect opportunity to offer some
Yeah, when it
transparency to the
suits
public.
you, we're transparent, and when it doesn't suit you, we keep it secret.
That's not fair.
Because
You
they
haven't
came
come
to us
to me
with
with
two
something.
other things, and I asked them to confirm that those were the transcripts you wanted released, and it was never confirmed. We were willing to entertain those
I'm
as
willing to
well.
entertain
Talking
others.
about an open meeting, period.
Well, I mean, I'm
Not about
willing to entertain
selecting
that if people want to.
Particular meetings are making them open. He's talking about just, every meeting should be open.
I'm willing to entertain that too, if you want to entertain it. I'm just saying that I'm bringing this one to the board this time. To say there might be others is not a reason not to approve this.
No, but I mean, I have advice here, and I have a perception that he's given that matches some of my own, that brings me to not want to release this
Fair
particular.
enough. I think you've made your position clear, and you're going to rely on Brian's opinion.
Well,
I don't know about Commissioner
I'm not
Kellner.
gonna-
I think
I'm gonna listen to
I think
Brian's
that we're,
Fair
I
enough.
think that we
Fair
are
enough.
at an impasse, and we should move on.
Is that what you call it?
I call it an impasse. It's not gonna go anywhere.
But I
at this
think we
point.
should leave the matter open.
Well, I don't think it's open. If you're not willing to discuss this one, why is it open? How does that make it
Well,
open?
because I like what he said, too.
So you want to open up all of
Well,
our
I said
meetings
I
to...
like what he said.
Okay.
I would like to hear from some of the other people who are going crazy after I said that.
Well, I don't know who's going crazy over it, but, well, I think it's unfortunate if we're not going to do it, because I think we're really doing a disservice to the community out there. But if that's the conclusion, I
But
guess that's the
I'm
conclusion.
leaving it on the table. In my head, I'm leaving it on the table.
You're leaving it on the table, so I will
The
bring it up.
concept.
I will bring it up next meeting.
Not
That's-
that, not
that's
this
fair enough,
particular one, but I'm
Commissioner.
bringing
Fair
this up
enough.
because I may
Fair
have
enough.
one that I want to bring up.
Fair enough,
And I
fair
think we
enough,
should
bring 'em.
turn the minutes into either a
Bring 'em.
draft opinion or
Bring
a
'em.
policy statement. All right. So now we go to new business. Prima facie ballot access rulings. It's my understanding that there were no issues with respect to the special elections called by the governor, but that there were some filings that you wanted to bring to the commissioners.
There are no prima facie issues with regard to the filings we received for the special election in the 102nd, 107th Assembly District. There is a general objection to the independent nominating petition that was received that may or may not percolate. We'll know in the days ahead. There were three separate single-page petitions of an individual attempting to run a designating petition for governor, an OTB petition for governor, and an independent nominating petition, both that would fail as to insufficient number of signatures, and they were filed prior to the first day to sign a petition.
Okay, let's not belabor this.
I don't see-
So the commissioners agree that those filings will be rejected.
Yes.
Agreed.
All right.
Do you need a
Those in
motion
favor
to
say-
that? I'm
That's
sorry, I'll
my
make the
motion.
motion if you want to make a motion.
Good.
I'll second.
Those in favor say aye.
Aye.
Opposed? All right, next is vote on the final adoption of the addition to Regulation 6210 relating to the audit tool, which has been published and then was revised, and the revised version has been posted for publication. And I think we have gotten some comments on it, which have been circulated. I think most of the comments are really that we should be using risk-limiting audits rather than the 3% audit, which really is an issue for the statute. As to the substance of the regulation itself, I think that we have reached a consensus within the agency.
Yes. Yep.
All right, so those in favor of adopting the regulation, say aye.
Aye.
Opposed? All right, it's adopted. Now, the next item on the agenda was to authorize the audit tool, but that there was no specific resolution submitted with respect to that. Well, but it doesn't have a procedure that is attached to it. So,
Well, I have, Commissioner, if I may, these are,
Okay.
we can pass them up to these guys here. These are the ones that we've had in, for a while now. Bob, you may have a answer. I mean, we've been looking for these for a couple of years or whatever, so we can certainly pass these on and push.
Whereas the rules and regulations regarding the audit tool
Right.
set forth have been adopted by the state.
so
And
I have no
discuss this.
problem using Clear Ballot Count System version 1.0.8 as an automated audit tool. But I think it should be done with respect, as part of the actual procedures for implementing it. And I got this draft this morning. So I would ask that we vote on that we actually publish the draft for comment and that we vote on it at the next meeting. As I say, as far as I'm concerned, it's a go for a clear ballot that,
So you want to wait on approving the clear ballot system until we publish and then
It
vote
should be
on
part of
on
the procedures, right.
Is there a problem with us voting on the procedures? Have we done this before? Is this something we normally do?
well, Actually, we did with respect to each of the voting systems. When we certified the system, we still had procedures for implementing those procedures, which Anna circulated. And
we adopted, I don't remember voting on them, that's all. Did we vote on them?
On what? On the procedure?
On the procedures themselves, I just don't remember.
Well, if these were the initial voting system procedures, that would have been 10 years ago or so. So I was not here at that point.
Okay.
We'll go back and look.
I don't believe you adopted the
I don't
procedures.
We'll go back and look.
That went out to the county boards. I was the deputy then. I don't think you adopted the procedures. I think you adopted the resolution and the reports.
Oh, at the time, we adopted the system, but I thought at some point.
I mean, all the procedures
why,
still have
why do
draft
we
written
need
across
to
the top of
adopt
them.
this resolution?
Because
What's-
the board needs to authorize an audit tool per 9/2/11, and that's what this resolution would do.
And to me, the authorization should be part of the procedures. So that it should be written into the procedures, and we'll authorize it.
There's no county that owns the clear ballot system now that's in the April 24th special election that I understand.
New York City did ask about whether or not we were authorizing them at this meeting.
Well, I have no problem telling them to go ahead and use it for the special, if there is a jurisdiction that wants to use it for the special. But I'd like to.
Can they do that without us voting on this?
No. They can do,
Well, the
they
special-
can do it,
we're
but they still have
meeting-
to do a 3% audit. This would be something,
Oh, I see.
this
It's just
this
a
wouldn't count
supplemental
as.
audit.
We're meeting before the special. I mean, we'd be
Okay.
meeting,
April,
we'd be
you're
meeting
in
in
April.
the first week in April, and all I'm asking is that we circulate this draft, which, as I say, was handed to me this morning.
Is there any problem with delay?
There's always problem with delay, but I'd have no problem with pushing this out to the counties, and if that's what the board decides.
Great.
Okay.
All right, well, thank you. All right, next is regulation on candidate websites, 6215, and to both provide for emergency adoption and publish for public comment. I think, as John Conklin pointed out before, that since the statute is effective immediately and we have a special election coming up, that we need to have the regulations in place for the special election.
Great.
All right, those in favor say aye.
Aye.
Opposed? All right, the regulation is adopted. And then the last item is the draft opinion related to contributions by federal candidates, which has been circulated. Is there any discussion on that?
Move the adoption.
Second. All right, those in favor say aye.
Aye.
Opposed? All right, so that has been adopted. Do we have any business for executive session?
Nope.
All right, so we just need to discuss the dates of our next meeting.
What do you,
We were talking about the first week in April?
Yeah.
are we looking
And then-
at first week of April? I think,
And then also
Easter is
May
April
3rd.
1.
Right.
Easter is April 1.
Correct.
I'm driving back Thursday Thursday.
I mean, I'm not being.
April 5?
Anything.
Oh, well, hang on one second, yeah.
You have some of the 6th, right?
And then we're also talking about May 3rd as a
two of them?
required
Third
meeting.
is the deadline to certify the federal candidates in the primary.
And April 5th.
Just one
He's got a
second.
check, he had an issue.
One date.
I think, but let's
Talking
just,
about May, right?
no, we're talking April.
April, I'm sorry.
April 5th right now is what we're looking at.
April 5th is okay.
April 5th is good. And then May 3rd, can you do May 3rd is the next question.
And I can do May 3rd.
Yeah, we'll do them both. April 5th, May 3rd. Okay?
No, we didn't add it here.
April 5th, May 3rd. So we need a motion to adjourn?
Those in favor of adjourning?
May 3rd?
Aye.
All right, we are stand adjourned. Next meeting.